is Alan Schwartzside. Alan, take it over. Take it away, my man.
Right. Well, before I do that, I wanted to give Denise and Ann a chance to add anything they wanted to add. I know that it's,
Up and running now?
yeah, they look like they're up and running
All
and
right.
like they're actually here. So I wanted to give them the chance before I run my mouth for the next 2 hours plus, just so that they don't have to sit here and listen to it if they choose not to.
Ladies,
I
anything
appreciate
further to say? I did it all because you were frozen up, so I apologize. The floor is yours.
Can you hear me?
Yeah.
Yes.
Okay, good morning. My name is Ann Smith. I'm the education manager here at Empire Management. I'm grateful to everyone for attending today. I will say that Denise is the authority on what's available, the services available through Empire. So I would like to pass it over to her, but I did want to say good morning and I apologize. I've had a lot of technical issues here this morning, but I think we're worked out now, so we're in good shape. Denise, do you have anything to add?
Yes, good morning, everyone, and thank you to Alan and the KBR team for this partnership. We're so thrilled to be able to provide this service for our residents in our surrounding communities and all across Florida. We're thrilled to be partnered with them as we move forward to serve our board members at a level of excellence. And we know this wonderful requirement to have this certification is so much fun, and KBR is going to make it fun for us today. No pressure, guys, right? But yes, we're Empire Management Group. We are a family-owned operation here, and we're father-son owned. They have owned our company for about 10 years. We were World of Homes prior to that. We do manage HOAs, COAs, and CDDs. We have been growing pretty rapidly in the past couple years and currently have 10 offices from St. Augustine, Sarasota, Tampa, Kissimmee, Leesburg, Claremont, Maitland, Daytona, and Melbourne, and have a long running good relationship with KBR. And again, we're excited to be a part of this service with them. We also do very passionate about education. As you can see, we have an education manager in place here that helps support not just our team, but our residents in the communities we serve and our board members. And just in that area, we will be hosting a Sunrise series on June 25th in the Melbourne area, where Alan with KBR will be one of our sponsoring vendors, will be on a panel. But we're doing a series that will kick off on the 25th that will be preparing for the storms. And we will be in hurricane season a couple weeks in at that point of the event. But there'll be a link later on in the chat. Board members are allowed to join us in person in Melbourne. We're on the 7th floor of the Hilton there. Beautiful ocean view we'll have during this. It's at 9 a.m. But you can also join us virtually as well. So I just wanted to add that. I'm sorry if I didn't hear what you guys were speaking about earlier. I was having some audio issues earlier, so I apologize. But also, too, if there's any way we can serve you with proposals or just in a consulting role, please reach out to us at empire@hoa.com.
Thank you, Denise. And a pleasure to be here with you. Thank you. Thank you
Thank
both.
you.
And before Alan gets started, I have a couple of people saying there's a bad echo, and I notice you are logged on with more than one device. Any of you logged on with more than one device, one to see, one to hear, turn off the microphone on one of them, and your echo should magically disappear. You have things that are too close together. Alan, back to you.
All right. Well, now I really will get started. My name's Alan Schwartzide. For those that don't already know me, I'm with K. Bender Rembam. A little bit about the firm, and then we'll go ahead and get started. Opened in 1993, I believe. Been doing nothing but representing community associations since then. 26 attorneys, another one coming and joining my office in Winter Springs on Monday to primarily address litigation. But I mean, we're 27 attorneys, or soon will be, 9 of whom are board certified in representing community associations, including me. One who's board certified in construction law, 4 offices throughout the state. So we've got the West Coast, the South, and my office here in Winter Springs. Anything that a community association needs, we've probably done it 50 to 1,000 times before, depending on what the specific issue is. And anything a community association needs is pretty much all we do. So if you're happy with your current counsel, great, stick with them. If you need a second opinion, you're not happy with counsel, you can't get responses, I just hope that after we're done today, you'll think about reaching out to us, and specifically reaching out to whoever the closest office is. Understand, we'll try and help out with whatever we can. But as Jeff mentioned, understand that this is a class. It's for educational purposes. It's to address your requirement. When we do the Q&A, when I advise on certain issues, I'm not giving you or your association legal advice, even though it might sound like it. So, all right, jumping right in, you should be seeing my screen at this point, or at least
Yep.
the PDF of the presentation. And we're just going to go ahead and jump right in and get started. So, and you will, as Jeff mentioned, get the slides as long as you do what you need to do after the class is done today. So I'm not going to go through the very basics, but I am going to try and reorganize my screen so I can see the whole thing. But we're going to skip this initially. Now, the first question we ask, why are we even here? Well, because the Florida statutes say we need to be. Within 90 days after being elected or appointed to the board, every new director needs to complete this class and get the certificate to either your manager, if that's who maintains your official records, or if you don't have a manager or you're on an accounting only platform with your management firm, you need to get that over to your secretary. So that goes in the official records. You do not get credit for this class until that certificate is in the official records, meaning, and we'll get to this in a minute, you technically can be suspended from service if you don't get this to your official records. I've said the same thing probably 3 times in 2 minutes because I have a lot of people who don't bother to ever get the certificate to the official records. And then all of a sudden, a year later, they're asking us for a copy because they individually lost it. So make sure once you get the certificate, it's valid for up to 4 years in an HOA. Make sure you get the certificate for each of these classes to your secretary or your manager as soon as you get it. That way you don't have to worry about whether you lost it or not. The other educational requirement, in addition to this 4 hours, this course being taken every 4 years, you also have, depending on the size of your community, you need to take two other possible groups of classes. And I'm not going to go through the curriculum for this class because you're going to go through the curriculum during the class with me. But okay, here's where we get to. If you don't take the class in the time that you're supposed to take it, which again, 90 days, you are suspended until you complete that requirement. Again, not just taking the class, but getting the certificate to the person who maintains the official records. Now, the board can fill that vacancy that you've created by not having taken the class, and understand that suspension is not, well, the manager said I'm suspended, the board said I'm suspended because someone voted on it. This is automatic under the statute. It just happens. So there's no arguing with it. There's no board vote needed. It's just, you didn't take the class, you're off the board for now. When you take the class and get the certificate in, you're back on, not a problem. And anyone that was appointed or elected to serve in your stead is now out. Now, if your term expires while you're off the board, sorry, but you're off. And you might not be eligible to serve again. So that's something to be careful of. Now, what I don't understand, the legislature says you need to take this class every 4 years, but keep the certificate for 5 after the director's election. Logic goes to the wind sometimes with the legislature that we have here in Florida, but that's what they've required. So understand you're keeping this certificate for a year after it expires. Why you would ever need that, I can't tell you, but you need to have it. And here's why I say why you would need that, I don't know. The failure to have the written certificate or educational certificate on file doesn't affect the validity of any board action. So why you would still need it a year later, I don't know. But that's what the legislature says, so that's what we do. Now, I mentioned you need to take 2 other classes of classes, if that makes sense. If you're in a community of less than 2,500 lots, you need to complete at least 4 hours of continuing education per year. If you're in 2,500 lots or more in your community, that's 8 hours per year. Now, one question that we get frequently, well, when does the year start? The answer is, who the hell knows? And the reason I say it that way is because DBPR, which is the government entity that really regulates most community association activities that aren't explicitly stated in the statutes, hasn't really told us when this year ends. My perspective, and a lot of attorneys' perspective in Florida, is that because of the way these laws were created in 2024, that year starts on July 1st of each year and ends on June 30th. Again, not legal advice, not something I can guarantee DBPR will eventually back up, but this is what they're telling us. Jeff?
I actually have it in writing from the DBPR, in writing from them, that they have the cycle just as what you mentioned.
Jeff, it's really cute that you think having it in writing means that they won't come after someone anyway. But thank you for that clarification. It is appreciated regardless. So keep in mind, these are classes that a lot of providers teach. Just like this class, you can go to many different people. We teach these online for free. In fact, I'm teaching one at 3 p.m. today. I'm barely going to have time to have lunch between classes, but we'll get it done. So understand, this is an annual requirement. Again, the law went into place July 1st, 2024. DBPR finally started approving classes just after July 1st, 2025. So my perspective is you have until the end of June of this year, if you're currently on the board, to get this done. Now, what's interesting is that this is in the same statute that requires you to take this class. It's not entirely clear whether not taking these classes means that you're also suspended, like I mentioned a minute ago. It seems like that was the intent. Some people say yes, some say no. You might want to ask your attorney. Hopefully, they're also teaching these classes and care about education as much as we do and Empire does. Okay, moving on to the purpose of Chapter 720. I'm not going to go through these things in detail. It's really the difference between an HOA and a condo. And as Jeff mentioned, hopefully, if you're only working with a condo or co-op, you've already left or you just really want to hear my voice because this is not the class for you. Okay, this is purely for HOAs. But the important thing to keep in mind, when people start looking on ChatGPT or Google Esquire, okay, a condo is a creature of statute. Most of what's in the statutes will govern over what's in their governing documents because the statute came first. If you're in an HOA, most likely, unless it's a fairly recent one, your documents came first. So we're going to get into Kaufman language in a minute. A lot of times the legislature can't tell an HOA what their contract may or may not say. And that's why this is important. But we're going to skip the rest of that. What version of the law applies? Well, I said we get into it in a minute, and we're already here. Kaufman analysis is something that your lawyer should be doing, not you individually, unless you're also a Florida barred attorney and know this area of law pretty well. But when I say Kaufman analysis, look at the third bullet here. This is what we're talking about. Okay, if the declaration says that it is subject or the association subject to Chapter 720, which is the HOA Act. It's the statute or set of statutes that governs Florida HOAs. So if your declaration says that it's subject to Chapter 720 as amended from time to time, then all of the legislative changes are going to apply to you. Every time the statute gets amended, the association's subject to that change. The reason for this is because you've already put in your documents, yeah, we think the legislature knows better than the people in our community. We want to let them make the decisions for us. Now, if you've looked at the statutory changes that have come down for HOAs over the last few years, not the best idea. Maybe 5 years ago, before all of the, frankly, before the building collapse in Surfside down in Miami, this might have been a good idea because the legislature was coming to attorneys that knew this area of law, asking for guidance, asking, does this statute, the way that we're trying to promote it and the way we're trying to amend it, does it make sense? Does it work? That question has not been asked very frequently in the last 5 or 6 years. So you might see changes that you don't love, and we'll get to some of them later today. But the bottom line is I don't recommend adding this language if you don't already have it. If you do have it, I recommend taking it out until the legislature goes back to asking the right questions about, does this statute make sense, rather than, do my constituents who know nothing about how a condo or an HOA operates want this change? Is this going to get me votes? Seems to be all that matters lately. So the hate towards HOAs is what the legislature is leaning in on. Now, generally speaking, going back to the beginning of this slide, the law that's in effect as of the date of a contract, here the contract is the declaration, the laws that's in effect as of the date that contract is made, so the date the declaration is recorded, is grafted into the contract. So that means if your declaration was recorded in 1960, the statutes in place in 1960 govern your community. The statutory amendments that came after that generally won't apply if they affect what we call substantive rights of the members or of the association. Substantive rights are, we have the right to vote. You're taking that away. You can't take that away without a provision that has Kaufman language that says, we're going to go ahead and adopt whatever the legislature thinks is a good idea for us. Okay, so if you don't have that language, then the legislature can't retroactively change your contract that's recorded in the county records, etc. It would be unconstitutional to do that if you haven't opted in by including Kaufman language in your declaration. Now, there's a difference also between substantive changes, which is changing existing rights, and procedural changes that change the way we go about doing things. The example I like to give is, do we have the right to fine or not? If we can't fine, but the declaration says we do, and the amendment to the legislature is what, or the legislation is what removed the right to fine, that's a substantive right being taken away by the legislature. Florida law doesn't allow that without Kaufman language. If it's what happened, I think it was 2022 or maybe 23, if you want to fine, you need to have a fining committee hearing. You need 14 days notice of that hearing. You need to send notice to the owner after the hearing, etc. The procedure for allowing that fine to take place, that's a procedural change. And if the legislature changes on a procedural note, that applies across the board, Kaufman language or not. So that's a lot of words to say. If you're not sure which one applies, go to your attorney. And if you think you know which one applies, you're probably wrong. So bottom line, I hate to be the guy that says you need a legal opinion, but on which one controls, ChatGPT will not get it right unless you feed your entire declaration to ChatGPT and it properly analyzes whether there's Kaufman language like an attorney would. That is a rare situation. I've actually tried it with several different models, ChatGPT, Copilot, and 3 others. Hasn't gotten it right once. So bottom line, and I'm not trying to negate or neg on AI. I think it's a very useful tool, but don't try and make it replace your attorney. I'm sorry, but it's not there yet. It might in the future, but it's not there yet. Moving along, we touched on all that. Conflicts between the statutes. Now, keep in mind, this is in the event of an actual conflict where the statute governing HOA says one thing, and Chapter 617, which governs not-for-profit corporations, which you also are running, by the way, if you're on the board, says another. This is, you need to have a board meeting. No, you don't need to have a board meeting. It is not, you need to have a board meeting. Here's the alternative to having a board meeting. So one example I like to use here is there's no actual conflict between Chapter 720 saying you need a board meeting to decide XYZ and Chapter 617 saying, yeah, okay, but instead of having a board meeting, you can use this unanimous written consent. A unanimous written consent is basically a resolution of the board that's signed by all the directors. And according to Chapter 617, it replaces a board meeting. That's not a conflict between the statutes. That's an alternative. But if there is a conflict, this slide says basically the more specific statute is going to govern over the general not-for-profit statute. So in the example here, your statute is Chapter 720. That's going to govern over Chapter 617 if there's an actual conflict. Again, that's whether there's a conflict is one that you need to run by your attorney. Conflicts within the documents. Now, not within the same document, but between the declaration, articles, and bylaws. We remember a little dabble, do you? The declaration is the document that controls. The articles come next in line in the event of a conflict, so the declaration controls over the articles. Articles and declaration control over the bylaws, and all of them control over any board-made rules, regulations, policies, architectural criteria, whatever the heck you want to call all these things that the board gets to vote on by itself. Now, to those who don't know what these documents are, let me spend a minute going through them. And I know that we're going through each one of these slides and taking a lot of time. Don't worry, we'll skip through a lot of the material later or go fast through it. But I think this is important as the absolute basics that every board member needs to understand. And let's be realistic, that's the purpose of this course and why the legislature thinks you need to take it. So I'm going to go through declaration. This is the contract between your members and the association, and between each member and the other members, and the tenants and everyone else, because this is a recorded document that says, here's how we're going to run this physical area. Everyone that walks onto your HOA property is subjected to this declaration. And the reason for that is that it's recorded in the county records, and everyone in the county and everyone in the world is considered on notice. It's called constructive notice of everything that's recorded in the county records. Does everyone actually look at it? No, no one but nerds like me actually look at what's in the county records, and real estate people, title agents, things like that. Most people never look at it. Most people buy into an HOA saying, I don't need to read the documents. I just need to know, can I rent my property or not? Good for you. You probably can, but if not, if the documents say otherwise. But the declaration is the one that'll usually include your use restrictions. You can't rent. You need to get permission to rent. You can't make changes to the property without architectural approval. Things of that nature are usually going to be in your declaration. Now, a lot of people refer to this as the CC&Rs, the covenants, conditions, and restrictions. Some of them include easements. You might include other things, but your declaration is your declaration of covenants. These are the things that run against every lot in the community. To the people that don't understand, well, this is my property, I can do what I want. No, you can do what you want, but within the confines of what the declaration allows. Now, the reason for that, when people challenge you on it, is that the declaration is almost always going to be recorded before the deed, transferring the property from the developer to any end owner. Which means, because Florida is a first in time, first in right state, the declaration was recorded first. The declaration controls even over the deed by which each owner took ownership of their property. So this is why you can tell people, okay, well, we can foreclose for $100 in unpaid assessments. Sounds ridiculous, but it's an option, and they agreed to it by buying in to an HOA that had covenants. They also buy in understanding that amendments to those covenants are possible. So if you amend, unless it's a leasing restriction in some instances, that amendment will also apply to everyone across the board. So people buy in, whether they know it or not, being completely subjected to what's in these governing documents. So again, we've got the declaration that is first in line, and it's going to be just presumed valid unless there's case law or federal law that says you can't have this provision. The articles of incorporation are basically the document that creates the corporation that you as directors are running. Whether you know it or not, you're running a business as a volunteer director of an association. Okay. The articles basically say, here's the name of the corporation, here's what it's created for. It's going to be the operation and maintenance of a Florida HOA. Your bylaws are going to be your procedural guide. The day-to-day operation is usually not covered there. It's going to be who can be on the board, who are the officers, and what are the qualifications for officers? How does your election get run? Things of that nature. So it's your guidebook of procedure. The declaration is the guidebook of what are you allowed and not allowed to do, what are the assessments and who pays them and how and when, etc. And the judges that review these are going to go from top to bottom, from least to highest scrutiny. The most scrutiny is going to be the things that the board gets to create. Okay, those rules, procedures, whatever you want to call them, there's case law that says the test for whether those are enforceable or not, is it reasonable? If yes, move on. If not, sorry, can't do it. And keep in mind, you can be completely unreasonable in the declaration, but not in a board-made rule. Second part of the test, is it contrary to anything that's in any of these three documents? If the answer is yes, can't enforce the rule. The last one's the one we see the biggest difficulty with. Is it supported by something in the declaration or the articles or the bylaws? If the answer to that is no, it's not supportable. So if you're going to create new rules, if you're amending your rules, or if you just have rules that haven't been reviewed, I'd recommend having your attorney take a look. Moving on to member meetings. And now we're going to get a little bit faster so we can get through a lot more, a lot quicker going forward. The association holds an annual meeting at the time, date, and place stated in or fixed in accordance with the bylaws. Again, that's your procedure guide. You look at the bylaws, it'll tell you how to hold your annual meeting. If you don't hold it exactly when and where your governing documents say, I have not seen someone successfully challenge an election because it was held a month after you were supposed to hold it. That doesn't mean you should intentionally say, I don't care what the bylaws say. Do your best to comply. But if you don't like what they say, that's what amendments are for. We have an entire class that talks about just amending your governing documents. Okay, if you're interested, I would go online and check that out. You won't get credit unless you're taking it live, but we do have recordings of every class we've done, and this one will be up in a couple days as well. The election needs to be held at or in conjunction with the annual meeting. Then you've also got special member meetings. That's literally any other meeting of the members held throughout the year. If it's not your annual meeting with your election being held, it's a special meeting. That's the entire definition. It's not the annual meeting. Now, that can be held if the board decides to hold one. For example, you're working on amendments or you're working on something else that the members get to vote on, which, by the way, candidly is not much. It's usually amending the governing documents and making changes to things in the budget, or the other one is if you're going to have $100,000 damages that you're seeking or greater, the members get to vote on that. That's almost the entire list. Everything else the board gets to decide. But if the members decide to try and get a special meeting together, if 10% of the total voting interest of the association file a petition with the board, then you have to hold that meeting. Now, there might be a different percentage stated in the governing documents. Note the difference here from a lot of other statutes that say unless the governing documents say otherwise. This doesn't specify unless a larger or smaller percentage is included in the documents. So if your documents say a percentage other than 10% gets to create this meeting obligation by the board, having a special meeting of the members, it doesn't matter whether it's higher or lower, you still need to follow that percentage. It's specifically in the statute. That's not a conflict with the statute because the statute basically defers to what's in the bylaws. Agendas, every meeting except the annual member meeting needs to have an agenda. And I'll get to why that's important later on, but it's also now a statutory requirement. Every member meeting, every board meeting, except the annual meeting needs to have an agenda. I'd recommend doing that anyway for reasons we'll discuss later, but it's basically to limit the time that you need to take with the members just going off on any topic that they might want to discuss. Special members meetings need to have an agenda as well, and it needs to be specific to, hey, here's what we're actually having this meeting for. The annual meeting, you're having your annual meeting. It's the election. That's what it's for. If you're going to discuss anything else, I would still have an agenda. And even if you're not discussing anything else, I'd have an agenda to limit what the members can bring up at that meeting. Now, we're not trying to cut them off. We're not trying to not be transparent. We're trying to be able to conduct the business of the association during that meeting. So when I say you need to cut off the members in any respect, it's not out of disrespect for them. It's out of saying we are running a business. We need to have the ability to run that business. All notices for this annual meeting or a special meeting need to provide the date, time, and location of the meeting. If the bylaws don't say how you're going to give it, it needs to be mailed, delivered, or electronically transmitted to all owners who have opted into electronic notices at least 14 days before the meeting. You also need an affidavit executed by whoever mailed those notices out if they're mailed, whoever emailed them if they're being emailed. I don't know of anyone that hand delivers their annual meeting or special meeting notices, but if that's the way you're doing it, you just need to attest to it. That's an affidavit. That affidavit goes in the official records, and the mailing address given in the official records is where you send all notices of anything. You're not going to just send it to the property and presume that's appropriate. If someone tells you, I don't live at the property, my mailing address is X, that's the mailing address you use. If someone opted into receiving notices by email and they gave you an email address, you're not just going to mail it, you're going to email it to them. Frankly, that saves you mailing costs as well. Electronic notice, you can email notice to anyone that opted in. Now you can opt in on paper, you can opt in electronically, it doesn't matter, but you do need to have something where the owner is actually saying, yes, I agree to accept these notices electronically going forward before you simply start emailing things out. So if you send an email blast to everyone whose email address you have for literally any reason, and they didn't opt into receiving notices that way, you have not given proper notice. You need to make sure that you're providing the appropriate method of notice, and that's after they opt in only. Broadcast notice is an option. I don't know anyone that actually does it. If you have questions about that, contact your attorney. And by January 1st, 2025, if your association is 100 or more lots, you need to have a website. Good news for anyone that's working with Empire, and frankly, 99% of management firms that I've ever worked with, their portal is going to serve as your website. You don't need a separate one. But you do need to make sure that the information that's required to be on a website is up on your portal if you are using management's portal for that purpose. That includes, and back to what we were talking about, the notice and agenda for each meeting. That goes up 14 days before the meeting. It goes on a special page in plain view that's labeled as notices with the notice and agenda for every meeting. And the association also needs to post any documents that the members are going to vote on. So if you're working on amendments, whatever it may be, within 7 days before the meeting. Now, I said within 7 days, let me clarify. That means at least 7 days before this meeting, all of that documentation needs to be on the website under the notices tab. Members get to participate in all member and board meetings. They have a right to attend all member meetings and all board meetings and to speak at any meeting regarding anything that's open for discussion by the board and anything that's on the agenda. So if the board responds to an owner and starts talking about a topic that wasn't on the agenda, you've now opened it for discussion. So if something is being raised by one of the members, it's not on the agenda, and you don't want to have each owner authorized to speak for at least 3 minutes on that agenda item alone, shut it down. Don't discuss it. Now, this is one of many, 7 to be specific, policies that I think every community association should have. The member participation at meetings policy, dictating, and the statutes specifically say you're allowed to have this. You can only speak for 3 minutes on every agenda item. You can't speak on anything that's not on the agenda. If you want to speak, you have to let us know in advance. If you want to participate in the meeting in any other way, you have to let us know. Here's how you're allowed to participate. You're not allowed to sit there and scream at everyone. You can record the meeting because Florida law says you're allowed to record any meeting of the members or of the board, but you can't walk around with your phone in people's faces like this while they're speaking. You can't get in the way, etc. That's policy number 1 that I think every community association should have. And it's something that, frankly, there are some communities that hire us just to work on those policies for them. Along with the first thing we do is pull the governing documents and compile them all into one document book. So there are some communities that work with counsel just to get these policies in place. Again, you can adopt these reasonable rules governing frequency, duration, and other manner of owner statements consistent with what we just said. If someone is handicapped or has a physical disability and they request an easier way of attending the meeting, whether that's physically in person, online because they physically can't get to the meeting but want to attend, you're going to want to run this by your attorney, but they have a right to an accommodation of the way you would normally do business. Okay, so if they have a need for an accommodation in order to serve a disability, that's really the standard here. You're going to need to provide that accommodation. That's policy number 2 that I think every community association should have. Instead of bringing each one of these to council, is how are we going to deal with disability-related requests? That's another class that we teach fairly regularly, and you can watch on our website. And frankly, I think the materials from that class are extremely useful because it basically goes through step by step with a breakdown of yes, no answers as to whether or not you're required to ask further questions or grant the accommodation. Again, anyone can record or videotape meetings. The board can adopt rules governing that issue as well. A quorum is 30% of the members now here's where we get into unless a lower number is in the bylaws. So 30% is now the official cap on what your quorum can be. So those of you that have a 50% quorum requirement, no, you don't. You have 30%. If it says you have a 10% quorum requirement in your governing documents, congrats, it's 10%. A majority of the voting interest present is generally what's required to adopt any vote of the members, unless your governing documents or the Florida statutes specifically say otherwise. Proxies generally can be used, not a problem. Proxy needs to be dated, include the date, time, and place of the meeting, and be signed by the person authorized to give the proxy. It's only effective for that particular meeting. So a general proxy, a power of attorney might not be good enough. Okay. A power of attorney is also very different from a general proxy. A general proxy is vote however you want on pretty much anything for this meeting. A limited proxy is it's good for this meeting only, and you have to vote the way that I'm telling you, but I can't make it to the meeting, so please submit this on my behalf. Now that's good for 90 days. So from the date that that meeting was supposed to take place, if you can't get enough people there to get a quorum, you can adjourn the meeting to a later date during the meeting, and that proxy that everyone got is still good for up to 90 days from the date of the original date of that meeting. Proxies can be revoked by whoever signs them. Any proxy holder can appoint someone as a substitute proxy if the original proxy allows them to do it, which is the way we normally prepare this, because we want to enfranchise as many voters as possible, meaning we want to gather as many votes as possible so that the members actually have a voice. And a copy is good enough. You don't have to have the original proxy as long as someone doesn't try and frankly forge the proxy to change the person that they're voting, the lot that they're voting on behalf of. I mentioned general versus limited. Both can be used to establish a quorum, but your governing documents may specify for any particular vote, or the statute may specify for any particular vote, that you can only use a limited proxy. Electronic voting, I won't go through in detail, but understand you've got a 14-day requirement before the election to adopt electronic voting. This is where you have a vendor that basically says, hey, we think that, it's easier to vote on your phone than to physically go into the meeting and submit a ballot. And that vendor is correct. And that vendor is the one that will set all this up for you. They will try and reach out to all your members. They'll try and get people to opt into electronic voting, which is required just like opting into electronic notices. And they'll also, at the same time, try and get everyone to opt in for those electronic notices. All of that is generally done at no charge. They charge for the amount of people that have actually opted in. Now, some of them will charge you a flat rate. Some will charge based on the number of people that are actually using their services, because that impacts how hard it is for them to get their job done. But the benefit of this is, again, everyone, regardless of where they're located, in Central Florida, we've got a lot of international people. If they can opt in and vote on their phone instead of having to mail something back internationally, they're going to be a lot more likely to do it. Now, I will tell you, I live next door to the person that collects the ballots at my elections, and I generally still will use this if I have the option, because I don't want to have to fill something out, put it back in the mail, and mail it back out, or even deliver it to my neighbor's mailbox. There are a lot of people just as lazy as me in this respect, and frankly, giving them the easy way out and letting them vote and be enfranchised, I think is the right way to do it. So again, this requires the members' consent. The vendor should be going out trying to get it, and I think it's a great idea. Moving on to general elections. Now, the good thing is your bylaws are going to dictate 99% of what your election is how your election is supposed to be held. In a condo, it's purely statutory and based on the Florida Administrative Code. I say it's a good thing in the association that your bylaws get to say what to do, and that's because the members and the board generally get to decide. It's not because it's any easier in an HOA. It's actually a lot more complicated because your attorney and your manager need to read through your bylaws to make sure there's nothing missing, need to read through the statute to make sure there's nothing missing, and try their best not to screw it up. And in reality, I hate to be blunt, but a lot of developers write these election provisions in a very unclear fashion, and in a way that makes it almost impossible to make sure that you get the election right. So what I'm seeing is a trend towards actually adopting the condo standard and the condo procedure, even for HOAs, when handling your election, because everyone knows how to handle it correctly. But that said, vacancies on the board caused by an expiring term are filled by an election. You can't just appoint someone. The elections held at or in conjunction with the annual meeting. They're conducted in accordance with the bylaws, and unless otherwise provided in the governing documents, a quorum is required in an HOA. If you're using ChatGPT or Google Esquire, you might see that only 30% is required to vote in order to hold an election. That is a condo statute. It is not mirrored in the HOA statutes. So if you're applying that and not the quorum that you're required to have, you're doing it wrong. Unless the governing documents say otherwise, directors are elected by a plurality of votes cast. In plain English, whoever gets the most votes wins. Anyone that is a member can serve on the board unless they're otherwise disqualified. Disqualification is you're delinquent in payment on the last date that you can nominate yourself for a director role. If you're taking nominations from the floor of the election meeting or the annual meeting, technically the last day you can nominate yourself is the date of the election. But it's that specific date, the last date that you can nominate yourself, that is the deciding factor. When we say delinquent, that also doesn't mean the assessment came due yesterday. Our governing documents say you're delinquent if you don't pay within 10 days. Well, I'm sorry, but for those 10 days, it's late, but it's not delinquent. So you need to be very careful. I see this mistake made very frequently. You need to be careful about what you use as the delinquency date. Anyone that's been convicted of a felony or anything that would have been a felony if it was committed in Florida and hasn't had their civil rights restored for at least 5 years can't serve on the board as of yet. A person who has pending criminal charges for any really HOA crimes is the way that I'll put it, can't serve on the board. And a member can nominate themselves or someone else can nominate them if the election process in the governing documents allows nominations in advance. You do not need to take nominations from the floor. So if your governing documents say that all nominations should be in 15 days before the election, or you may accept nominations as long as 15 days before the election, you're not required to allow nominations from the floor. That doesn't mean you don't have the option of allowing nominations from the floor. But if you're going to allow mail-in ballots, you're not giving those people the opportunity to be voted for. So my suggestion is make that decision in advance. If it's dictated in your bylaws, just follow the bylaws. Election by acclamation is one possibility. Basically, an election is not required unless you actually have more candidates than open spots. If you have 5 spots on the board, everyone's up for re-election because you don't have staggered terms, and you have 5 people willing to serve on the board, those 5 people are on the board. Why would you go through the effort of counting ballots, holding the election, etc. on election day if everyone is going to make it on the board anyway? There's no point, and the statute doesn't require that. If you have 6 people, now you need to count the ballots. If you have 4 people, still fine. The members can vote in person or in proxy unless the governing documents say otherwise. Hopefully they don't, because it's a lot easier to count ballots that you've got in advance and you've been able to kind of go through and verify whether the person voting had the opportunity and authority to vote. If the governing documents allow voting by secret absentee ballot, it needs to be basically done in the condo style with an inner and outer envelope. All ballots are counted on the day of the annual meeting. That doesn't mean you can't check off those outer envelopes a day or so in advance of the annual meeting that you've got in advance by saying, okay, this has John's name on the outside. He's at this address. I'm confirming on my voter roster that he's eligible to vote, and I'm marking him as having submitted a ballot. This way on election day, you don't need to go through all of that. Now, that is done in an open meeting. But my experience has been, unless you expect a challenge, no one's showing up at that meeting. Okay. Unless the bylaws say otherwise, the director's term is 1 year. So if you don't have in your governing documents, oh, the director serves staggered terms of 3, 2, and 1 year, etc., the term is a year and you have an election every year. You only have 60 days to raise an election challenge after the result is announced. So if you raise it on day 61, meaning you file your election petition with DBPR or you file a lawsuit governing an election challenge saying, I don't think they followed the proper procedure during that election. Sorry, but you're out of luck. And I already addressed the venue as being DBPR with binding arbitration. DBPR, again, is the government entity that governs these particular issues. That would be an arbitrator selected by the government, not selected by the parties, that's deciding who wins and who loses. If you are talking about going straight to court, that's my recommendation because a judge is probably going to actually follow precedent. And the arbitrators in Florida, DBPR, have essentially stated that they don't have any obligation to follow precedent, even though it's binding Florida law for the last 50 years. And that's why it's not that I think they're bad people or bad lawyers or that they are lawyers. It's that they don't seem to care whether they decided the exact same issue a week ago in favor of an association. They can still rule against the association with no harm done on their end, but harm to the association a week later. So they can be arbitrary as arbitrators, and that's the problem I have with DBPR arbitration. Election of officers is generally done in your organizational meeting, which usually will be held immediately following the actual election, the annual meeting. Now understand the distinction between officers, directors, and members. So you're wearing probably 3 hats if you are an officer of your HOA. A member is literally a lot owner. That's the definition in every declaration I've ever looked at. It may not be worded that way, but effectively that's what we're talking about. The owners, those are the members. Your directors, that's the board. Those are the people that make motions, second motions, and vote on motions or abstain from voting at board meetings. And by the way, we haven't gotten to board meetings yet, but that is the only difference between a board meeting and a member meeting. Does the board vote or do the members vote? If the board votes, it's a board meeting. If it's a member meeting, the members vote. So directors are the people that make most of the decisions for the association. The officers do not make any decisions in their capacity as officers. The officers are the president, the vice president, secretary, treasurer. If you don't know what the responsibilities of each one of those are, feel free to reach out. But in reality, I'll call them placeholders. And the reason I say that is because in reality, if you've got a qualified management firm managing your community, 90% of the work that the officers do, not the directors, but the officers, is going to be done by your manager. Your treasurer is responsible for the finances. Guess who does that when you've got a management firm working for you? Management. Your secretary is going to be responsible for the affidavits of mailing documents. They're going to be responsible for keeping the books, the physical original records books. Guess who does that when you have a management firm? It's the manager. Okay, so the president has a meaningful role because they're going to be the one that signs all the contracts. Secretary might sign as well. Treasurer might still sign documents pertaining to association finances. But for the most part, the roles of the officers that are described in the bylaws are going to be taken on by management for the most part. But again, the directors are the ones that make decisions. The officers may be the same people, but they're not deciding anything as officers. This becomes really important when you've got a president that says, I'm the president, I get to make this decision. Hell no, you don't. The board makes the decisions. The president gets the authority from the board. Now, unless you've delegated as a board authority to make certain decisions to certain people, that's a different story. But if the board hasn't decided across the board, we're going to let the president decide X, Y, and Z. We're going to let the treasurer just handle the funds without a board vote. That's not how it works. So what you can do, and this is the last thing in this slide, changing officers midterm. When you've got a president who, after being told by the other directors, after being told by management, after being told by the attorney, stop making unilateral decisions, you don't have that authority. Okay, the board can put on the agenda and vote to remove them as president and put someone else in that role. There's nothing that precludes changing officers midstream. So you elected someone who's never served on a board, hasn't taken this class yet. They're doing whatever the hell they want because they think they have the authority to do it because they're the president. Maybe they don't need to be the president anymore. and you're a month into their term, and then at the next board meeting after they were elected as president, elected to the board, they're now just a director at large. They don't have an officer role anymore. That's okay. There's nothing wrong with that. And frankly, I've never seen anyone win a lawsuit over being removed as president, even if it's just because you wanted someone else as president and they did nothing wrong. All right, off my soapbox. If you need me to guide you through what election fraud is, I don't know what to tell you. But bottom line, you can't do anything other than campaign that is going to change the way someone votes. You cannot give them free things other than maybe like buttons and things like that. You can have food at an event, but you can't take them, for example, to Ruth's Chris and say, I'll buy you this $50 steak if you vote for me. Not an option. Okay. You can't prevent them from voting. You can't threaten them. You can't bribe them. You can't do anything with respect to an election that you wouldn't want one of your politicians doing. Okay. So we're going to kind of skip this. And honestly, if I have to go through more than what's on these slides, you probably should resign from serving on the board anyway. So there are new laws. Understand, if you know that someone perpetuated an election fraud and don't report it, you are just as guilty. And that in and of itself is a crime. That's the one thing I think is important to understand. That in and of itself, not reporting that election fraud is a first degree misdemeanor if you know about it. Okay. And when I say know about it, that includes knowing, helping, advising, etc. Moving on. Vacancies on the board, unless the bylaws say otherwise, if there's a vacancy and it's not because a term expired, except recalls, which we'll discuss later, that is two options. One, the directors hold another election, which we just went through some of the procedure. Why the heck would you want to do that? The alternative, which is obviously a better option in my opinion, is the board votes someone onto the board. The remaining directors have a vote. It's on the agenda, just like you can vote the officers in, you can vote directors in. You can't just vote them out without a recall or a provision in the bylaws that treats them as having abandoned their seat on the board. But the board in and of itself cannot vote someone else off the board, even if your bylaws say that they can, because there are statutes that say there's a different procedure that overrides what's in your governing documents, unless, again, they're treated as having abandoned their seat. So a board member elected to fill a vacancy serves the rest of that term. It's not you serve a brand new term. You just serve until the person that came off the board would have been off the board and they termed out. All right, moving on to the board, and we'll skip some of this because I've already gone through it with respect to member meetings, but this is probably the most important slide that you'll hear today. So if you've been ignoring me, nodding off, wake up, please, and listen. The officers and directors have what's called a fiduciary responsibility to the owners. What this means is that as a director of the HOA, you are treated as a trustee of the association. This is the highest duty imposed by Florida law. Okay, so you are held to a very high standard. You can be sued individually, not as a member of the association, but for actions taken by you as a director or an officer if you violate what's called that fiduciary duty. Now, the duty is to do what is reasonably believed to have been in the best interest of the association and not malicious, intended to harm someone, etc. That doesn't mean you can't do covenant enforcement and collection. It just means it can't be done because you hate the other guy. Okay, that's really what we're talking about. And it can't make decisions because you would have benefited from it more than any other person in the community. You're required to act reasonably. We have what's called the business judgment rule. So I'm going to explain it in plain English. I call this the dumbest guy in the room standard. Okay, you have the highest standard imposed by Florida law is what the directors are required to comply with. But it's judged by what you could reasonably have believed to be in the best interest of the association based on the information available to you, based on advice of experts like your counsel, your manager, your engineers and architects, and based on information that you should have had available or should have asked about. So you do have the obligation to get an expert opinion if there's an issue that requires one. It could be a breach of fiduciary duty to not get that opinion, or, for example, to violate advice of counsel without getting advice from another attorney who's willing to give you that advice and testify that they gave you that advice to the extent that that comes out in court. Okay. Now, this is where I bring up what I call the third most important bill you'll pay all year long. Directors and officers liability insurance. That is what protects the individual directors and officers when those types of lawsuits are filed. If you don't have it, get it now or get off the board. And I hate to ever advocate for resigning, but the reality is if you're not protected, hopefully there's an indemnity provision in your bylaws that protects you. But I would much rather have an insurance policy rather than rely on the association to take care of me after I get sued personally. I said that's the third most important. Management is number one. They are going to give you more help, more guidance, more assistance than any other vendor that you work with. And your attorney's number two, obviously, because we kind of do the same thing, but only when we're asked for it. Now, association powers are generally exercised by the board unless there's something that specifies you need a member vote. This is why I said earlier, the board makes almost every decision in a community association. We've already dealt with most of this. So directors can't vote by secret ballot at board meetings, except when you're electing the officers. And you can use, this is where we have a lot of people get it wrong. You can use email to communicate, but you cannot vote by email. So you can decide here are the 5 vendors that we're going to consider. You can't decide we're going to go with this vendor via email. If you do improperly decide via email, you still need to have the full discussion and the full vote and basically ratify that decision at the next board meeting. Board meeting notices are 48 hours in advance posted in the community. We talked about mailing 14 days in advance for member meetings, so this is different. But if you're talking about a special assessment or you're talking about something that is a change to use of the lots, this is where a lot of people get it wrong. Changes to use of the lots, not the common areas, the lots themselves. So what I can do on my own property, not what I can do within the common areas of the community. Those will both require a 14-day mailed notice instead of just the 48 hours posting. So understand, 99% of board meetings is a 48-hour posted notice. If it's a special assessment or a change to use restrictions within the lots, 14 days. Okay. That notice, like I said, for member meetings needs to go on the association website. Members can participate at board meetings exactly the same way that they can participate at all member meetings. Those meetings are open. Meetings of the board are open to the members, except meetings to discuss confidential attorney-client privileged matters, meeting with attorneys. I see people holding closed meetings and not inviting me. I don't need to be invited. I don't care if I'm invited, but you can't hold it in a closed session because it's a legal issue without having counsel present to create that privilege. Okay, you still need counsel present, and these closed meetings also do need to be noticed to the members. The members just can't attend and participate. And then the other option for a closed meeting is discussing personnel matters. We've kind of gone back and forth with DBPR about whether management personnel counts as association personnel. That's one you'll want to get an opinion from your attorney on. If you hire people directly and they are your association employees, that is 100% a personnel matter. Let's see. We already discussed all this with respect to member meetings, so we can skip it. Director, officer, or committee member can't be compensated except if the members allow it. That's by majority vote of all members. They get the same financial benefit as everyone else. So you had an insurance claim that paid out and it pays out to everyone. They're reimbursed for out-of-pocket expenses that are approved in advance by the association. Fees or compensation authorized in the governing documents or again by a vote of majority of the voting interests. And a developer or its representative serving as a director or an officer or a committee member can be paid because that's their job. If you are not a developer rep, you are a volunteer. That means you generally don't get paid unless there's something that's very rare in your governing documents. Now, this goes along with kickbacks. I know you'll be shocked. You cannot accept a kickback, period. Okay, you can't solicit, offer to accept, or accept it. It's basically anything of value that you get that others didn't. And you got it, presumably, because of your role as a director or officer. It's an incentive to do work with someone. Okay. If you knowingly violate this, it's now a third-degree felony subject to monetary damages. Bottom line, leave the TV at the store. You don't need a free one that badly. Okay. If someone offers you that TV, I've had a situation come up where a vendor said, you know what, you do a lot of business with us. I'm going to offer you a generator for free. But it goes at the president's house. That's a kickback. If it goes at the clubhouse to power association facilities, that's not a kickback. That's a benefit of working with someone. If it goes to the president's house or some director's house, that's not okay. Okay. Now, the exception, food to be consumed at a business meeting with a value of less than $25 per person. So I can take you to the ale house, but I can't take you to Crest Chop House. Okay. That is acceptable. A service or good received in connection with trade fairs or education programs. You come to CAI trade show. We can give you our little, pens and pads and stress balls and rulers and all kinds of other stuff. That's fine because it's an educational program or a trade fair. Same thing with the Empire trade show that'll be coming up in a while. Same thing with the condo and HOA expos that happen throughout the state. All these things are trade fairs. You can accept tchotchkes there. You can't accept the TV there. All right, moving on. Grounds for immediate removal. Director or officer that's charged with these crimes by information or indictment is off the board. Forgery of ballot envelopes or other election fraud, theft or embezzlement of association funds or property, tampering with physical evidence, or refusing to allow inspections or copying of official records in furtherance of a crime, obstruction of justice, or any other criminal violation under the HOA Act. Now, note what I said here. Charged by information or indictment. This isn't John down the road said Alan stole a whole bunch of money from the association or Alan embezzled from the association. This is the cops came, they did an investigation. There's a prosecutor that gets paid by the state who said there's enough evidence here to actually charge someone with a crime. Until you're charged with that crime, this doesn't happen. You're not removed for this reason. Okay? That doesn't mean you won't be ostracized by the board necessarily, but it does mean that you're still on the board until that criminal charge comes down. The board fills that vacancy until the end of the term or until the end of the period of suspension. That suspension ends if the term is still active and the person is found not guilty or the charges are dropped. Okay, but if that criminal charge is pending, that person can't be added to any other board or as an officer of any association. And if they want the official records, the court in that criminal case needs to actually approve their review or access to official records. So it's pursuant to court order only. Director who becomes more than 90 days delinquent in paying any fee, fine, or other monetary obligations, so not just assessments, is off the board. They're treated as abandoning their seat. Again, this is not a member vote. This is not a board vote. This is not a recall. You are automatically off the board. You do not get to come back on until that full delinquency has been paid and the other directors decide that you are going to come back on. They don't have an obligation even after you pay, because this is not a suspension, to bring you back on the board. Conflicts of interest. Basically, if you have an interest in a company that's going to do business with the association or with a person that's going to do business directly with the association, and that interest is family in nature, we call it the third degree of consanguinity, meaning up to great grandparents, I think, or is it just grandparents? one, two, three. Yeah, great grandparents, great grandchildren, or basically siblings, spouses, cousins, second cousins is about as far as we go. But bottom line, if you've got a family relationship with anyone that's going to do business with the association, you need to disclose it in advance, at least 14 days before the board votes on it. You need to have at least 2/3 of the other directors vote in favor of the agreement. The agreement needs to be reasonable and it needs to be fair to the association. And regardless of whether this disclosure happened at the next regular or special member meeting, the contract needs to be disclosed, and the members, if they choose to make a motion, can terminate that contract by a majority vote of the people that are there at that meeting. As long as you've got a quorum at that meeting, the members can vote to say, nope, we don't think it's a fair contract, or we just don't like it, or they've done a bad job. Okay. Now that might be the annual meeting if you're not holding special meetings throughout the year. That might be the next meeting where these members get to make that vote. If that contract is canceled, the association's only going to pay up through the date of termination. No termination fees are paid, none of the other stuff, because this conflict existed, even if it was disclosed. Now, keep in mind, we're talking about conflicts, and the legislature talks about them as though they're the worst thing in the world. You can't have a conflict. Yes, you can. There's just a procedure that needs to be followed when it pops up. It could be the best thing for you. If I make a deal with my cousin, where my cousin's going to work for my association and I'm on the board, which, by the way, if I just happen to live there and my cousin's proposing to do business, there's no conflict because I'm not the one making the decision. I'm not on the board. But if I make that proposal and I am on the board, my cousin might give us the best possible deal that we could get out of every vendor in the entire area. Why would I not be allowed to get that great deal for the association? So a conflict isn't necessarily bad. It's just something that needs to be disclosed. And it needs to be disclosed the way that we outline in this slide. Moving on to official records. We have this huge list of what the official records entail, and it's basically all the documents that are involved in the operation of this community. Okay, there is a long list. Here's why I'm not going to bother reading it. Look at the last bullet point here. Every other written record of the association not specifically identified which are related to the operation of the association. The official records are literally anything written pertaining to association operations. That could be a napkin that someone handed you. It's still written. Okay, it doesn't matter what it is. And the DBPR is now pushing for even digital records that have not been printed are being considered official records of the association. So if it exists, you need to get it into the official records. This is one reason I recommend having one email address for the entire board that gets copied on any official business so that all of the emails that are sent there can be added to the official records. Moving on. And that's what they are. That those inspections are another thing we'll get to in a minute. Official records retention is policy number 3. Okay, the association is actually obligated to have a records retention policy. You were required to have it by July 1st, 2024. You maintain all the records for at least 7 years unless the governing documents require a longer time. Bids received by the association, election-related materials, those are only kept for 1 year. But your retention policy should dictate how you're going to keep and maintain those records, where they're maintained, what goes on the website and what doesn't, what's subject to inspection and what's not, etc. Basically, how are we going to keep these documents? And when it's time to dispose of them, how and when are we going to actually do that? So that's policy number 3. And this one is state mandated. You must have it. I'm not aware of any trouble you could really get in if you don't, but you're supposed to be telling your members, here's how the records are maintained. Now, there is a whole list of records that are not accessible to the members at all. The attorney-client or work product privilege materials related to litigation. There's a dispute that I hear among attorneys as to whether that privilege goes away after the dispute is over. My perspective is no dispute is ever over because you never know when someone's going to reopen litigation. and say, oh, well, I'm looking to reopen this because I wasn't given notice of this XYZ. Well, now all of a sudden you've got the dispute open, but you've handed all of the privileged materials that disclose your strategy to the other side because you were obligated to do it. So my perspective is, because that makes no sense, that privilege extends forever, and that is essentially what the Florida statutes governing privilege say. So we're relying on the statutes governing privilege there, not these particular records inspection statutes. Information obtained in connection with approvals of lease, sale, or other transfers of a parcel. That's usually going to be your application form, your background checks, things of that nature. Anything personal is generally not going to be subject to inspection. Same thing with information in gated communities in connection with guests' visits or owners or residents. And then we get into the true, what we call PPI, private personal information. Any personal identifying information excluding name, lot designation, mailing address, and property address. None of this other information goes out to the people. Personnel records of management employees. That doesn't mean that your management contract is not subject to inspection. This is talking about direct employees of the association. Medical records, you might get those in connection with a fair housing related accommodation or modification request. You might get it in connection with a personal injury case where someone claims they were injured on association property and you've got HIPAA rights, etc. And then electronic security measures used by the association to safeguard data, including passwords. Obviously, you don't want someone having direct access to make changes like you heard about people doing or you see in movies where you're changing your grades because you were able to access the teacher's laptop. We don't want to allow that. And then same reason, software and operating systems that allow manipulation of data. So you're not providing access to QuickBooks, you're providing the QuickBooks report regarding what they asked for, and then affirmative knowledge acknowledgments made pursuant to Chapter 720, 3085. This is basically acknowledging that you're accepting your invoices to be sent to a different in a different manner. Attorney-client privilege. The only thing that I really want to mention here is the last bullet here. Only the board gets to waive the attorney-client privilege. The president doesn't get to decide, oh, it's not a problem to waive the privilege. I'll give this confidential information over to the other side or to John down the street because he asked for it. The board gets to decide whether that privilege is broken. I, as your attorney, if I'm your attorney, don't get to decide. I could be hauled into court, called to testify, and I still wouldn't be allowed under oath to give out information talking about the things that I discuss with my clients in a confidential attorney-client privilege setting. It's only the board that gets to waive the privilege. If any director starts waiving privilege, you need to let them know in harsh language, frankly, that if they do it again, there will either be a recall effort or there will be some kind of sanction, and it might be monetary, it might be otherwise, but the board is going to pursue an injunction against them to try and get them to stop giving out the information that they're supposed to be, according to their fiduciary duty, holding close to the vest, so to speak. All right. The association can print and distribute a directory containing names, lot addresses, and phone numbers of each owner. The owner can select to exclude their phone number by requesting it in writing. That means that the association can give out your phone number unless you ask the association not to do so. It's not the other way around where they can only give it out if you allow it. So understand, the board gets to do this unless the owner says no. And the owner can also disclose or allow disclosure of other information. Providing rules and covenants. Hopefully you've already done it because it was required nearly 2 years ago now. So I'm going to skip that. Access to official records is the inspection portion of the official records we're talking about. This is policy number 4 that I think every community association should have. Your records inspection procedures, the dollars that you're going to charge if you are charging for records inspections, etc. So unless the governing documents say otherwise, you need to provide the records within 45 miles of the community or within the same county. Now, I had a client just recently ask this week, well, what if we're in Kissimmee and the community's in Claremont? As long as it's within 45 miles, you're good, even if it's not in the same county. Okay. But if it's within one of those two, you're good. Now, the important part here is you get this official records inspection request. Doesn't need to be phrased or titled as an official records inspection request. It just needs to say, I want to view some records of the association. You then have 10 business days after you receive it to provide access to the records. It's not 10 business days to respond. It's 10 business days to provide the records. So you're not going to respond on business day 10 saying you can come and look at this a week from now, because that would be a violation of the statute. Now, to comply, you can have a copy of the records available in the community. You can make them available electronically, which could be via your management portal if you want to upload every single official record so that you don't have to comply with any of these requests. Or you can allow the records to be viewed in electronic format on a computer and printed upon request. Now, what the statute doesn't expressly include yet, that the condo statute does, be careful about this one, is, well, we have everything online. Good luck. You can make them available electronically via the internet. You can't tell someone it's all online. Good luck. I know that sounds like a distinction without a difference, but there is a difference there. If the request is submitted by certified mail, return receipt requested, and access is not provided within the 10 business days, the courts are going to presume that the association's failure to comply was intentional. Understand, if they request the records in some other way, you can still get dinged for not having produced the records within 10 business days. Okay? It's just that there's a presumption, if it is submitted that way, that the failure was intentional. It shifts the burden from the owner proving that you intentionally failed to produce records to the association to prove that it wasn't intentional. So you want that burden to be on the owners. Now, this is one of the things that can be in your official records inspection policy. How do these requests need to be submitted? And you can say, we're not going to accept any requests that are not submitted by first certified mail return or receipt requested. That's an option. But understand, you've got a $500 gift involved here if you don't comply with the timeline that's set forth in the statute. If you don't produce the records in 10 business days, it's $50 per calendar day, minimum damages up to 10 days, with the calculation beginning on business day 11. And you owe them $50 per calendar day after that for not having produced the request. So if you provide it on business day 15, you've got 5 days worth of $50 charges that you technically owe the owner, in addition to any attorney's fees and costs, in addition to any actual damages they suffer by not having the documents on time. Now, I've never seen anyone actually have actual damages, but you never know what someone's going to come up with. So just be careful. Access to official records. If an association gets a subpoena from law enforcement, you only have 5 business days to produce all of the records to that law enforcement agency, and you need to help with the investigation to the extent allowed by law. I've never really seen this come into play. I don't know of any community that's refusing access to official records to law enforcement, but it's in the law now. Official records crimes. Now understand, any director or manager who knowingly, willfully, and repeatedly, meaning 2 or more violations in 12 months, fails to provide access to official records. It says with the intent of causing harm. I've never seen any allegation that there wasn't intent to cause harm. That is now a second-degree misdemeanor. Understand also that the 2 or more violations in a 12-month period was in the Condo Act as well, and it was removed last year so that any violation of this is now a misdemeanor. Bottom line, produce the records. Someone that is asking for them is going to get them anyway, unless there's a legitimate reason not to produce them, which is outlined in the statute. If you intend to not produce something, my recommendation is run that intent by counsel to make sure that it's actually something that you can support before the individual making that decision gets charged with a misdemeanor or risks one. Again, you can create these reasonable rules governing frequency, meaning how often someone can ask for it, the time, location, notice, records to be inspected, and manner of the inspection. That's your inspection policy. You can't require an owner to tell you or show you why they're asking for the records. They have an absolute right to review anything that's not protected under Florida law. You also can't limit their right to inspect the records to less than 1 8-hour business day per month. If they want to make copies on their own device, meaning a camera, an iPad, a phone, whatever, Fine, they get it free of charge. They're responsible for making the copies, though. If they're gonna have you make copies, you can either make them through something like Kinko's or one of those services, and the actual cost of those goes out to the owner, meaning you can force them to pay. Anything up to 25 pages is free. Anything beyond that, they pay your cost. If you're making the copies as an association, up to 25 cents per page beyond those first 25 pages is what you're allowed to charge. Now, you do need to provide a vendor invoice if you're using Kinko's or one of those services to have them pay in advance of having to produce the copies. And understand there are a lot of tire kickers that frankly will end up in a situation where you've actually produced records, or I'm sorry, you've copied these records and then they refuse to pay. Well, there's nothing we can do about that. You've now incurred the cost, but they're not going to get their records until they actually pay. Personnel costs. If it's more than 25, a half hour, you can charge up to $20 an hour. Now, a lot of managers are at somewhere between $100 and $250 an hour, according to their contract. Okay, the association can charge the $20 to the owner. The other X amount that wasn't recovered does stay on the association's tab. Websites, we've kind of gone through, again, 100 more lots. You're required to have this website. There's a list of items that need to go on it. I'm not going to go through those in detail because I think you can read. If not, you probably wouldn't be here and you probably wouldn't have gotten elected. If that's an issue on your end, you might want to take a class regarding reading rather than this class, or at least in addition to this class. You do need to ensure that the things that are not accessible to owners via records inspection, meaning that they're not protected or that they are protected, are not posted on the website, meaning they don't get access to it. You can redact, whether it's in response to a records inspection or on the website, anything that they're supposed to not have access to. So your account numbers, things of that nature, you can redact. Again, it's kind of a no harm, no foul. If you fail to redact or put something up inadvertently, you're not really responsible for any damages that arise. All right, amending the governing documents, we actually have an entire class on, but the percentage that's required to get that amendment is capped at 2/3 of the association members. Okay, amendments to the articles and bylaws that impose quorum or voting requirements that are more than that are not required to be approved by the greater requirement. Meaning, if you're saying that your quorum is 50%, again, we go back to that 30% I mentioned earlier. Let's see, the format of any amendment, unless it's like a C change and you're completely changing what's in there, you need to underline new text and strike out any deleted text. So you're showing the members what they're actually voting to change. Lenders consent, that's something that's in a lot of governing documents. It basically has been changed by Florida law. If the lender is supposed to consent on amendments to the governing documents, you give them what we call negative notice now. So if after 60 days, they don't say, yes, we have a problem with this, we're objecting, then they're treated as having consented to the amendment. Okay, now this does require that you go out and search for every lender against every lot in your community. As a result, what we'll customarily do if I'm drafting these amendments where there is lender consent needed and it impacts the lender's rights. If it doesn't impact the lender's rights, you no longer need that consent. But if it does, then what you're going to do, in my opinion, you're going to make that amendment so that it doesn't take effect with respect to any existing mortgages as of the date of recording the amendment. So you don't need the consent of anyone because it will only affect people who don't yet have any rights in the community. Okay, moving on. The effective date of an amendment is when it's recorded, and within 30 days after recording the amendment, you need to provide copies to the members. If you fail to do that, that doesn't invalidate the amendment. It just means that you screwed it up. And if you've provided a copy in advance of voting, which frankly is what I think you should be doing, so that the members get to see the actual text that they're voting on versus just a proxy that says, basically we're amending section whatever of the bylaws to make amendments easier in the future. If they've actually seen the text in advance, you can just give them the recording information so that they can pull a copy of the recorded document. We're going to skip through this because we're running a little bit behind schedule. Government filings. Understand, despite being a not-for-profit, you still need to maintain an active corporate status by filing an annual report with the state every year. You still have an income tax filing. That doesn't mean that you're going to have to pay taxes. It just means you're going to have to file. Moving on to meeting minutes. All meetings require minutes. Doesn't matter that it's a meeting of a committee. Doesn't matter that it's a closed meeting. Now, understand, this is something I see people making a mistake on frequently. Minutes don't need to be verbatim records of what was discussed. If someone says, I'm voicing an objection for the record, I don't care. Good for you. Voice whatever you want. We don't have a legal obligation to write down every single word and every objection that someone chooses to raise during a meeting. So it's not, John discussed this, Jane mentioned that that might not work for this reason, blah, 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 blah. It's, here's who made a motion, here's what the motion was, here's who seconded the motion, here's how each of the directors voted, here's the outcome, and here's who abstained from voting. That's your entire set of meeting minutes, nothing more. Because when you have all of that detail in there, what you're doing is wasting time for either the secretary or your manager who's drafting the minutes, and you're adding fuel to the fire. You're telling the owners, hey, if anyone has a problem with what we did and they raised an objection during this meeting, here's your proof. Congratulations. You're handing them the proof that according to them, you screwed it up. Versus them having to prove and having the obligation to prove, hey, I objected to this and here was my rationale and blah, blah, blah. You're not trying to hide the ball. You're trying not to hand a claim to one of your members. They're maintained in writing or any form that can be converted to writing within a reasonable time. They do need to be adopted formally at a subsequent meeting, whether it's board meeting minutes, adopted by the board, member meeting minutes, adopted by the members at the next meeting. And again, every vote or abstention is recorded in the minutes. Material alterations in reality is something that is not in the HOA statute, it's in the condo statute. This is where you're changing something and changing how it looks. So you're painting in a different color. Usually in an HOA context, there's nothing in the governing documents that requires a member vote before you make that material alteration. The board gets to make those decisions. But what you might have is the board doesn't get to make this decision if you're going to spend more than $5,000. The members get to vote if it's more than a $10,000 expense or more than a certain percentage of the annual budget. Now understand, there is case law that essentially says if it's something the board has obligation to maintain, repair, or replace, and that's what you're doing, then you have the legal obligation within your fiduciary obligations, your fiduciary duty, to just get it done. That doesn't mean you should disenfranchise the members by not asking for the vote, but my opinion is you kind of let the members know we're going to let you vote on it. We're hoping to get your support. And then if you don't get the support, you probably still do what you were planning on doing anyway, unless your governing documents say otherwise. We walk through rules and regulations and what votes are needed, so I'm going to skip through some of this. Marketable Record Title Act is a very important concept. 30 years after the original recording of the declaration covenants begin to expire on a lot-by-lot basis. Now, we say after recording the declaration because that's the easier date to ascertain. It's not because it's legally appropriate or accurate. Realistically, this starts happening 30 years from the date each lot is sold by the developer to someone who's going to occupy the lot. And rather than, in a community, we represent some that are 4,000 plus lots, rather than calculate that date for every single lot in the community and track it and record a preservation instrument before the first one expires, we're just going to track the date of recording the declaration and make sure that before it's even feasible for any of these to expire on a lot by lot basis, it's been taken care of. Now, I can't speak to what other firms do. I know for clients of our Orlando office, I will essentially track every single MARTA expiration for clients whose documents will expire or covenants will expire at some point. And 3 years in advance of that date of recording the declaration plus 30 years, I'm reaching out to my clients every 6 months. And then once we get to a year, it's every 3 months to try and give them every opportunity to do the right thing and preserve those covenants. Now, if they expire, they become unenforceable, meaning you can have the guy next door to you with the house that's painted pink with purple polka dots, meaning that if someone doesn't pay their assessments, you can't foreclose, you can't lien because you don't have a covenant anymore that says so. And if that's what happens because you didn't record that preservation in time, you need to do this revitalization process that's described at the bottom, which is essentially getting a majority of the members to approve revitalizing, reinvigorating, reestablishing the existing covenants, and then bringing it to the government to approve the revitalization, getting it recorded, and then moving on. I can promise you a preservation will be a third, maybe a quarter, depending on the governing documents, sometimes a fifth of the cost of having to revitalize your covenants. And you don't need to go door to door. It's a board only vote versus a revitalization, which is a member vote. So bottom line, make sure that you're aware. Keep in mind, you have a legal obligation at the first board meeting after the organizational meeting every year to mention this Marketable Record Title Act. What you really should be doing is verifying the date that's 30 years after the recording of the declaration or 30 years after the recording of the last preservation, and making sure that during this coming year, we don't need to worry about getting this document recorded, this preservation instrument. Emergency powers. If there's a hurricane or something else that might cause injury or damage to the association or its property or its members, and a state of emergency is declared, these powers kick in. Now, to save some time, I'm going to skip them, but this is especially important during hurricane season. And this might be an appropriate thing to mention during our upcoming event with Empire towards the end of next month, specifically speaking about, okay, well, here's what happens in the event of an emergency. The association gets more powers that you wouldn't have without that stated state of emergency. Now, once the state of emergency is over, these powers also go back away. They disappear. But understand, they don't exist until you've got a state of emergency that might cause damage or injury to the association or to the members. All right. Debit cards. You can't use a debit card issued in the name of the association or billed directly to the association for association expenses unless the obligation is directly stated in the budget, meaning that maintenance item, repair item, replacement item is directly in the budget and you're spending exactly what the budget says, or you've actually had the dollar figure and the expense and the specific item approved by the board in meeting minutes that have been adopted in advance of spending the money. So what do I suggest? Get a credit card. Law doesn't apply to credit cards. Or if you want to use a debit card, don't have it in the name of the association and don't have it billed directly to the association. Get reimbursed. There's nothing in the law that governs reimbursements as being a crime. Okay, the association, the members, you can't use a debit card without having that advance approval. I talked about if you're going to file a lawsuit that's worth more than $100,000, keep in mind that $100,000 is in damages. It doesn't include your attorney's fees and costs. So when you sit there and you say, our attorney quoted us that to go to trial on this would probably be 65 grand and we're seeking 50 grand in damages and that exceeds the 100,000. No, it doesn't. It absolutely does not. You do not need a member vote. Now, if you're pursuing a, construction defect claim that's more than 100 grand in damages that you're pursuing, 100% you're going to need that vote. And anyone that does construction defect work or anyone that works with you on these types of matters should be aware of this requirement. Moving on to architectural control. Again, these standards are generally adopted by the board, but they need to be reasonably and equitably applied and enforced, meaning no selective enforcement allowed. Okay, these need to be standards that are published guidelines authorized by the declaration. That's two important concepts. You can't just have unpublished rules, meaning you haven't adopted them at a board meeting, that the architectural review committee or your board is enforcing against the members. Okay, you need to give them notice that they have obligations here before you tell them they didn't comply with those obligations. And they need to be authorized by the declaration. Remember what we discussed earlier. If a rule's not authorized by the declaration, it's not authorized and it's not enforceable. So if the association's enforcing things like it doesn't meet the standard of the rest of the community, that's questionable at best. The aesthetics alone is no longer good enough under Florida law. The statutes specifically say it needs to be specifically stated or reasonably inferred. So if you have well, we don't like this, okay, make sure you have an amendment in place or a governing document in place, preferably the declaration, that says you have the right to establish these architectural criteria. One of the attorneys in my office and I have actually created what we call the kitchen sink amendment when it comes to architectural criteria. And it's like a one-page amendment that basically says the association has the right to address architectural criteria governing, and it's just a laundry list of everything we've seen over the last 20 years of practice in a set of architectural criteria. So it's authorizing basically whatever the board wants to include unless it conflicts with an existing provision of the declaration. So we'll take those criteria out if the declaration says you're allowed to have X. Okay, well that comes out of the kitchen sink. But this is the easy way of knowing if you've got this adopted, the board can really do what it needs to do in adopting criteria that you want. Now, if you're denying an owner's application, you need to specify the rule that you're relying on in denying it if you choose to deny it. Okay, if you're granting it, okay, great. If you're denying it, the actual denial needs to state your request has been denied because Article 5, Section 4 of the Declaration prohibits any basketball hoops from being installed on a lot, and that is what you're requesting to do. Denied. Have a nice day. It can't just be denied because we don't like it. That doesn't work anymore. All right. Now, here's where we get into the government stepping on toes a little bit. Associations allegedly can enforce or adopt covenants, rules, or guidelines that limit or place requirements on the interior of a structure that you can't see outside. Requires the review and approval of plans and specs for central AC, refrigeration, heating, or ventilation systems if it's not visible from those same areas, and is substantially similar to systems that are approved for or recommended by the association. And then this is another one. Again, any of these, my opinion is, it is a substantive change to what you can and can't restrict on a parcel. And therefore, if your governing documents don't have that Kaufman language that we discussed earlier, the as amended from time to time language, the government can't tell you what you can and can't enforce that's in a contract. That would be unconstitutional. So this is the one that says you can't tell anyone that you can't install, display, or store anything on a parcel that's not visible from the frontage, an adjacent parcel, an adjacent common area, or a community golf course. In other words, if you can't see it outside the lot, you can't enforce it. And again, I disagree unless you've got that Kaufman language in your governing documents. Hurricane protection specs is item number 5 that this one is another one. Every community in Florida is obligated to have hurricane protection specifications. If you don't have them, work with your attorney to adopt them now, because as soon as hurricane season starts, you're going to wish you had them. Vehicle restrictions is another one that the Florida statutes have governed. That again, if you don't have that Kaufman language, my opinion is that this statute simply doesn't apply to your community, and you can choose to allow it to apply or not. You can't tell anyone that they can't park their personal vehicle, including pickup trucks, in a driveway or anywhere else that they're allowed to park according to state, county, or municipal regulations. You can't tell an owner, guest, or anyone else that they can't park their work vehicle, regardless of the official signage or visible designations, that aren't a 25,000-pound vehicle in their driveway. Okay. The bottom line is the legislature is telling you can't tell people they can't park trucks or commercial vehicles in their driveway or anywhere else that they're allowed to park. My perspective is if that covenant was adopted and it was in your declaration or it was in your rules before the statute came into play, it's still enforceable if you don't have Kaufman language. If you have Kaufman language, you're out of luck. So This is one, if before you start deciding, we're not going to enforce this anymore because the statute says we can't, run it by your attorney, find out whether that's legally accurate or not before you start giving up the association's rights because you won't be able to get them back later. Same thing here, contractor restrictions. You can't prohibit an owner from having a contractor or worker on the property just because they're not on a preferred vendor list or because they don't have professional licensure or don't have insurance. I don't get that one. So you're telling me that someone who has no idea what they're doing can come onto our property, do a bunch of work, screw a bunch of things up that impact everyone else, and our recourse is just, well, good luck suing them and having them go out of business. And then you get a piece of paper that says it's a final judgment that has zero value whatsoever. Anyway, budgeting. The most important thing I can say about your budget is that you need to properly maintain a budget that really allows you to comply with your obligations to maintain and operate the community to the level described in the declaration. You can't artificially reduce the budget just to look like Mr. Nice Guy and get reelected. That is a breach of fiduciary duty to say, we're just not going to take care of the community so that we can charge the members less. You're not going to back into the budget, meaning, well, you know what? We've spent half the budget, so all these things that are needed in the community, we're just going to choose not to do them because we don't have the money for it in our budget. You're going to amend the budget to properly account for what it really takes to maintain and operate this community. When you don't do that, you end up with one of two things, or possibly both. You end up with breach of fiduciary duty claims because the directors didn't bother to make sure that your budget actually covers what you need, or you end up with massive special assessments. Guess how much the members are going to love you when you come up with a huge special assessment that they don't have the money to pay because you didn't allow them to account for it over the course of the fiscal year. Okay, so off the soapbox, but understand you need to properly maintain the budget so that you can maintain and operate the community. You can address the legal and physical needs of the association. You can pay your manager and all your other vendors, and you can get done what needs to be done to keep up the association on an operational and maintenance level. It needs to separately set out everything that you're going to pay, everything you expect to bring in. It includes reserves if you've got any. Understand generally an HOA does not have reserves unless they've been established by the budget, by the bylaws or your declaration, by the developer. And this is where I see people mess up. If it's in the budget because the developer put it in the budget, that is not a real reserve. That is a category of line items in your budget. To be established properly by the developer, my opinion's always been there needs to be either meeting minutes that the developer turns over to you, or a written resolution is the more likely one that gets turned over to you. If all they did was shove it into the budget, that's not a real reserve. And then finally, you can have a member vote to adopt HOA reserves. Now, you can use last year's actual expenses to plan for next year's budget. You might want to adopt that plus some inflation level, so that you know that you're covering added costs, at least to some extent. And dollars in the operating section of the budget are not restricted to one line item. You can use them for anything that's in the budget, not anything at all, but anything that's authorized in the governing documents should be in your budget, and you can use that operating account for whatever you need. So the fact that you reserved $100,000 for beautification and landscaping doesn't mean that's all it can be spent on unless that's a truly established reserve. Operating expenses, I'm not going to go into detail because it's whatever you're going to spend. Reserves, I'm not going to go into in detail because frankly, most HOAs don't have them. If you have questions on that, this is one I'll be happy to answer questions via email later on. Let's see. Okay. Notice of adoption of the budget. If the governing documents don't say otherwise, notice of the board meeting when the budget is going to be considered and adopted must be posted in the community 48 hours before the meeting. Now, a lot of people will tell you you need 14 days notice for that budget meeting. That's only the case according to Florida law if you're going to adopt a special assessment during that budget meeting. Usually you do it separately, but some communities will do them together. Understand if your bylaws say you need to give more notice, you should. And a lot of communities will give 14 days notice just to avoid the argument that you were supposed to do it. Nothing wrong with that. But I would also post 48 hours in advance so that you're giving the notice that is actually required by Florida law. Before the budget's adopted, unless the governing documents say otherwise, you are not required to provide a copy of the budget, but I would consider doing it so that the members don't have the argument, well, I didn't know it was going in the budget, and if I knew you guys were going to be this crazy, I would have shown up and argued with you at the budget meeting. Okay, good for you, buddy, but the board gets to make this decision anyway. But after the budget's adopted, the association must provide each member with a copy or a written notice that a copy is available upon request at no charge. That's essentially a records inspection request, but you're not charging for a copy of the budget. So take that out of the calculation of how many pages you're providing to that owner if they do a records inspection request that includes the budget and it's done this way. The association also needs to list the budget on the website or the app. Assessments and foreclosures is another class we have. I'm going to kind of blitz through these, but understand we talked about what's required for special assessments, so we'll skip those. Requirements to provide an accounting. If someone asks you for an accounting, meaning basically a ledger of everything they owe, you need to provide that accounting within 15 business days after you receive that written request. If you don't, and what is due is a fine, that fine is waived. What people are misunderstanding and have been since this law came into effect is none of the assessments, interest, or late fees are waived. None of the administrative fees associated with collecting the debt are waived. It's just the fines that are on the account that disappear if you don't comply with this. Now, after an owner requests this from the board, they can't request it again for at least 90 calendar days. Now, it doesn't specify in the statute whether that's 90 days from the date of the request or 90 days from the date of production. To be safe, I would say 90 days from the date of production because that's going to be the later date. You're going to want to be more compliant than not, unfortunately, on this. But frankly, if you're fining, I think you're wasting your time anyway, and I'm not going to bother getting on my soapbox about that one. Interest is collectible regardless of what the governing documents say, unless they say zero interest is collectible. But if you don't have a rate provided, you go to 18% per year, which is in the statute. If you do have a rate provided in the declaration or bylaws, you go with whatever the rate in those documents is. Late fees are different. You are not charging late fees unless your governing documents allow it, and only in the amounts that the governing documents allow. Now, that amount can't exceed the greater of $25 or 5% of each installment. Understand, you cannot charge interest on interest. You cannot charge interest on late fees. You charge it on assessments. You also can't charge another late fee of $25 if you have quarterly assessments and you're charging those late fees monthly. So if you have a $50 assessment every quarter, $25 is going to be way more than that 5% figure that we quoted in the second bullet here. So you're not charging $25 a month, you're charging $25 a quarter. It's per installment. The other thing is attorney's fees and costs. Unlike most other collection activity, you're entitled to an enforcement activity and other litigation. You're entitled to your fees and costs regardless of whether a lawsuit is filed, regardless of when the owner pays. Except you can't charge fees for a notice of late assessment. And we'll get to what that is in just a moment. All payments are applied first to interest, then to late fees, then to costs and attorney's fees, and then to assessments. So if an owner owes $500 in assessments and a whole bunch of other charges, and they only pay $500, your response is, thank you, you still owe the rest. That's not payment in full unless the board unilaterally decides to accept it as full payment. But if it's $500 and they owe $300 in other charges, they still owe the $300 as an assessment because of the way that this statute applies the payments. Notice of late assessment. I'm not going to go through the entire pre-suit collection process because frankly, we just don't have time. But it's essentially you're going through a notice of late assessment, good for 30 days, says you owe a bunch of money. Intent to lien, good for 45 days, says you still owe a bunch of money. If you don't pay it, we're going to lien your property. Then a notice of intent to foreclose says we're going to file a foreclosure lawsuit if you don't pay. Safe harbor, if a lender forecloses, you need to run by your attorney what the lender or the third party that bought the property actually owes, because there is a big analysis that needs to be done. I'm running behind schedule, so I'm going to skip through a lot of this, but understand we do have a full class on financial reporting, a full class on collection. The important parts of this are you have up to 120 days to provide your financial reports. The fact that you're not for profit doesn't mean you don't need those financial reports. So understand you've got 21 days after the financial report's completed or received from a third party to produce a copy to every member, or tell them that a copy is available upon request at no charge to the member. Your level of financial reporting is generally based on how many dollars you bring in a calendar year, or in a fiscal year, actually. If you're less than $150, you basically have an Excel spreadsheet that's a ledger. 150,000 or more, but less than 300,000, you're now compiled financials. At least 300,000, but less than 500,000. Now you need a CPA for a reviewed financial, and 500,000 or more, or at least 1,000 lots in your community. You now need an audited financial statement, which is a review of every document pertaining to your operation throughout the year that's done by your CPA, and you get a full report of everything. You can raise or reduce the reporting level by a member vote. Usually that's a majority of the voting interests. And in order to change that level, 20% of the owners can petition the board for a higher financial reporting level, but you do need to hold a meeting where a majority of the total voting interest needs to vote. That 20% is just to get the meeting in place. Same thing with lowering the reporting level. These are some financial disclosures that you put in your financial reports if you don't have reserves, that essentially say we don't have reserves, we're not putting money away for X or any of our assets, and as a result there may be special assessments. If something that costs a lot of money fails, then we wouldn't normally put in our budget because it's not something that's expected to be needed every single fiscal year. Contracts and bids. Contracts need to be in writing if it can't be fully performed within a year for the purchase or lease of materials or equipment, and if it's a service type contract. This is called the statute of frauds. It's not intended to be fraudulent. It's just a legal term. You should, in my opinion, either be having your counsel review every single contract, or having a form addendum that your counsel prepares that hopefully will allow for every contract to protect you way more than any vendor you're working with intended to protect you in their contract. Understand 99% of contracts you're going to see as an association director were prepared by a vendor who's going to protect themselves in the initial draft and hope that you don't bother to have anyone take a closer look. I see this in construction. I see this in painting. I see it in landscaping. That doesn't mean that they're wrong or that they're bad. It just means that you need to protect yourself just like they're doing. So I would suggest having, even if it's a $3,000 contract, have counsel prepare a form addendum for you to attach to every one of those contracts. Spend the same, maybe $2,000 to $5,000 having that available to you. And then the ones that are closer to 50 to 100,000 or more, those are the ones you have counsel look at individually. But please, when you get that estimate and it's one piece of paper that has no terms and conditions and you sign it, that's your contract. That's all you have. You don't have an attorney's fee provision if they screw up. You don't have an out to terminate early without claiming a breach of the contract. You don't have anything. So just be very careful with what you sign and what you're willing to agree to. Bidding, if you have a contract where the cost in the aggregate is more than 10% of the total annual budget, including reserves, you need competitive bids for materials and services. You do not need to ever accept the lowest bid. You go with whatever vendor you think will do the best job. You don't need to get bids in the event of an emergency, or if this vendor is the only provider of that particular service in your county. Okay, moving on. These specific contracts, and they're with your experts, are exempt from bidding requirements. Your employees, your attorneys, accountants, architects, engineers, CAMs, if by competitive bid, those can be made for up to 3 years, and your landscape architect. Now, these contracts need to be in writing, but you don't need to get competitive bids for any of them. So when someone says I'm getting 3 bids for my attorney because I have to, no, you don't. If you like Alan, work with Alan. If you like John down the road, work with John down the road. If you're not 100% sure, that's when you get bids. All right, estoppel certificates is part of the collection process. It's basically a catch-all of, hey, we're selling this property, we're refinancing this property, we're going to close a transaction based on what association you are telling me. And we're allowed to rely on what you tell me, as here is the entire list during the 30 days that this estoppel certificate is good for, the entire list of items that are going to need to happen in order for this property to have a completely clean slate with the association. So it's, here's all the assessments that are going to accrue. Here's all the ones that are already owed. Here's all the violations on the property. It's literally, we're going to outline everything that these people need to do in order to come clean and start from scratch. Anything that's not listed in the estoppel certificate is generally waived, meaning the association can no longer enforce it if that closing takes place relying on the estoppel certificate. So you want to make sure that this is being prepared very carefully. What I frequently see is violations are not listed, and then the closing happens and the association wants us to go after it, and we find out, well, you had an estoppel certificate go out a year ago, the violation popped up 2 years ago, no one told us about it. Kind of nothing we can do there. Okay, you've got attorney's fees that you've spent having us do collection work that we haven't charged because you're on our special collection retainer program where we defer all the fees and costs until the file gets closed out. So you wouldn't see a bill. You've got attorney's fees that we've spent in covenant enforcement that you haven't been billed for yet because we just spent the time to do the work in the last month before the bill went out. You don't know about these charges. So if you have anything that's with counsel regarding that property, you need to run that by counsel before producing the estoppel certificate. You got 10 business days to produce it unless it's done on a rush basis. This is just the information that needs to go on it. Here are the fees that you can charge. There is a DBPR list of what these fees are, so I'm not going to go through it in detail, but it's here. The one big thing that I'll point out is if you are late in delivering this estoppel certificate, so more than 10 business days, you don't get to charge anything for preparing it, but you still have the obligation to prepare it. So once you get this request in, just like an official records inspection request, a recall petition, these are time-sensitive issues that you need to address immediately. If a board member gets it, send it to your manager right away. If a manager gets it, if attorneys are getting involved, it needs to go to the attorneys right away. And for example, if we have a collection file open, it may take us a couple days to calculate the balance owed. That comes to us right away to do that calculation, not on business day 10. Okay, we don't have this issue with Empire, but there are other managers and management firms that, oh, that's right, this is with counsel. Maybe we should get them to fill out some of this. Well, we can't always get to it within 1 business day. So just be careful about getting this out. If the closing doesn't happen and someone requests the money back that they spent for the estoppel certificate, you send that money back to them. A lot of people don't know about this portion of the statute, but that charge goes on the account as an assessment. So you're still getting your money, but you're not keeping the money. So until you actually have that closing, don't presume that this is your money yet. Again, it's good for 30 or 35 days. If it's mailed, it's 35. I've never seen anyone mail one in the 18 years I've been practicing. Bottom line, you are going to produce it within 30 days. If you find that you're going to produce it within 10 days, it's good for 30. If you find that anything in it is now no longer accurate or was never accurate, you need to amend it ASAP, and it's good for another 30 days, and that amendment is done at no charge. So understand, if the information is no longer accurate, make the change, send it out before they close relying on something that's inaccurate. Covenant enforcement is another class we offer. I'm not going to go through it in detail, but I literally wrote the book on the subject for HOAs. Bottom line, don't bother with fining. Do use use right suspensions. And if you're not sure if you can enforce something or not, ask your attorney. And I am going to skip a lot of this so we can get to the Q&A, and you guys that want to get out of here can. So we're going to skip a bunch of information. Self-help. Okay, so we're going to skip the rest. We didn't touch on the fair housing stuff very much. We didn't touch on recalls. Those are all classes that we do offer independent of the board certification. We do offer them for HOA credit, which, as I mentioned right at the beginning, you guys need to get as directors anyway. So hopefully the next time we're teaching those, and you can go on our website at kbrlegal.com, click the calendar link and see all of our upcoming classes. But I'm going to go ahead and shut up because I see Jeff jump back in here, and I'm going to give him an opportunity to say what he needs to say. Understand you guys might need to step away. I understand that this might have been advertised to some extent for 1 hour. We advertised it for 2.5. But you know, if you've stuck around this long, you're not required to stay for the Q&A in order to get your credit. But I'm going to let Jeff clarify all that too.
Yeah, I have a solution here, guys, for the little faux pas here. So in the chat, we just placed the link for the required evaluation. So what you're going to do is you're going to click on that link, and it's going to take you to, this is the normal part. This, with every one of our classes, we have the evaluation. So when you click on the on the link, it opens up in the browser here. And I just added here, with today's session, I intended to receive. I want you to make sure you read this carefully and fill this out properly. I think some of you were under the impression you were getting CEUs for this class, the way it was advertised, while some of you know that you were getting if you were a newer board member, needed the certification. The truth is, most of the material here is chopped up and is what comprises the CEU classes in years forward. So just make sure that you properly choose the correct selection here with today's May 27th session. I intended to receive my certification. Or you're choosing CEUs for HOA board members, or if you're a manager, choose that you were a manager intending to get CAM credit. And then fill out the rest as normal. Hit submit. And then after you hit submit, you'll get to this page here. And this 5th bullet point is a area where you can click to download and save today's slides. But just for some clarification, Alan covered it in the first few slides. Anytime you sign up for any class, okay, whether it's K-Bender Rembam or another collaborator with Empire, or if it's something we're doing on our own, the language you always want to look for, always, CEU and certification are two different things. CEU is continuing education units. That is what Alan described in the first few slides. Why are we here? And he went over education for board members as mandated by the 2024 legislation, that board members must now have, HOA board members must now have either 4 or 8 credits per year. So you always want to look for language that says CEU or continuing education units, or just simply continuing education. That is never to be considered the same as certification. Certification is something brand new board members would need. And some of you were chatting with me during this class that, hey, I already took this course. Why am I here? So anyway, I hope that clears up some of the confusion. But that's the language you got to look for in any course advertisements. CEU versus certification. Two different things. I'm going to place the link into the chat one more time, Lester, and for others. So press the chat button. Not to be confused with the Q&A. Q&A is a different module altogether. The chat is different. So go ahead and press the chat button so it appears, and in about 20 seconds, I'll place the link in there once again. Alan and Ann, back to you guys for some Q&A.
All right. Well, I'm going to try and blitz through. It looks like we've only got 23 questions. So I'm going to basically cut it off at the 107 question. Does this mean that suspended board member, Herman asks, do suspended board members count toward quorum even if they're at the meeting? If you haven't reported to them that they're off the board, then they will still count. Again, anything that director did without knowing that they were suspended, they still count. Their vote still counts. Their quorum still counts. Once you tell them they're suspended, they no longer count for any purpose until their suspension is lifted, so to speak. Who sets the agenda for the member annual meeting? The board does, George. How can a member get an item on the agenda other than a 10% rule to force a meeting? That's the only way. The members can't force the board to put something on the agenda. Sam asked pretty much the same question, so we'll skip that. Hopefully I answered. George thinks that owner's comments should be summarized in the minutes. If not, the board can sidestep liability. by saying they didn't know. That's exactly what I'm suggesting, is that you sidestep the obligation. Listen, I understand the desire to have the members have their say and to put everything in writing and to hold the board accountable. You can still do that, but the association is the entity that I represent in all these cases and who management represents and is supposed to be protecting. So if you're on the board and you are suggesting that the association should not protect the association, that I can't agree with. Let's see. George also says HOAs should do away with proxy since they destroy the secrecy of the vote. They don't destroy the secrecy of the vote. They just change who's voting on behalf of whom. So if you're using proxies as the only document, that they shouldn't be used as the ballot. There's a difference between a proxy and a ballot that I guess I didn't explain, but a ballot is usually how you work. That's generally how you do it. So a ballot is the document you use to actually vote. A proxy is a separate document that just says this person can vote on my behalf. I don't know how that would destroy any secrecy. George disagrees with board members electing replacement board members. It'd be the same as the governor resigning. Let's have the mayor elect every replacement. Well, that's not even remotely what is happening. It would be like having 4 governors elect the 5th governor. So I don't really understand the commentary. One person, one secret vote, that's the way it should always work. Well, if that were the case, that's what the legislature would say, and it's not. But that doesn't mean that every individual board can't decide to do it that way, George. Nothing wrong with that. Robert says if you have a master association that has several associations within the master, and then the question cuts off. So I guess I don't have a question there. Sam asks, do I need to pay out of my own pocket for directors being sued? Well, if you're the director being sued, you might, but hopefully you've got the directors and officers liability insurance policy that'll kick in so that the association is paying the deductible and you're not paying out of pocket for your own defense. Now, there are exclusions and exceptions to those policies, so there might also be a provision of the bylaws, the declaration, Sam, that basically says the association needs to indemnify and defend the directors if they're sued for anything done in their official capacity as directors. So it's really going to just depend on whether what you're being sued for is covered by either of those 2 provisions, either the insurance policy that protects directors and officers from liability or your indemnification provisions of your governing documents. Herman asks, regarding voting, does the board need to have a quorum when they're voting? What if a board member leaves the meeting and there's no longer a quorum? Is that vote still valid? If the board is having a meeting at all, there needs to be a quorum, just like the members would need a quorum for their meeting. Now, the difference is the quorum at a board meeting is only a quorum of the directors, which usually is a majority of however many directors you're supposed to have. So I do see this question come up a lot. Well, we only have 3 directors, but our bylaws say we're supposed to have 5. Okay, well, every single director needs to show up in order for you to vote on anything at that point. Now, if a director steps away and doesn't vote on something, if their vote's not counted, then they're not counted. And my opinion would be that they don't count towards the quorum for that vote. They might for that meeting, but they might not for that vote. So sorry, Herman, I know there's no specific item that I'm talking about, but it might be something that you run by counsel so that you have a written opinion and you can rely on that written opinion rather than be accused of doing something wrong later on. George asks, if the governing documents are silent, can the board decide to donate money to a charity? I'm not aware of any basis for a not-for-profit to donate to a nonprofit entity. So my answer would be probably no, but the board can promote people donating to a charity and collect money for that organization. But there's nothing in Florida law that explicitly allows the association to donate money to a charity out of the funds paid by the members. No. Robert asks, if you have a master association with several subs and the individuals total over 750, does the master have to send a meeting notice to each homeowner, or can it be sent to each management company? That's going to depend on who the members are in your master association, Robert. If your members are the individual homeowners, then the members individually get those notices. Only if the individual communities agree to send out those letters from management would that be sufficient. But the problem is going to be that the association is now relying on someone who doesn't serve the master association for purposes of ensuring that you're complying with your obligation to provide these notices. So my suggestion is if the members of the subs are also the members of the association, your notice needs to go to each individual homeowner within the community. If the members are the subs themselves, different story, and you just send notice to to each sub instead of each owner. George asks if you're recording people coming and going, why are you even wasting time and money if it isn't an official record? The only logical reason for recording coming and going would be if there was an issue. Well, again, it is an official record, which is what I said. But the coming and going, which I presume you're referring to when we were talking about whether the people being scanned in at the gate, so to speak, that's an official record, but it's not something that the owners are entitled to request and receive as part of a records inspection. Um, Keith asked about, does he need to stay for 2 hours? Yes, you need to stay for 2 hours to get 2 hours of credit. Sorry. Our HOA board confuses emails official as requested in writing versus social dinner specials. Also, we publish a directory, which some people consider official emails and others complain it was published. Please clarify. Well, DBPR has basically said that anything pertaining to the business operation of the association, even if it's only in an email account, is an official record. Things pertaining to dinner specials, unless the association is the one providing those dinners, is not. And the association is paying for it, even if other people are paying them back. Otherwise, not an official record. So again, if it pertains to the operation of the community, the maintenance of the community, yeah, that's going to be an official record. If not, nope, not relevant. George, an abuse of legal action. Okay, I'm not sure what you're referring to. George seems to just be arguing with a lot of what I'm saying, so I don't mean to be rude, but rather than have him dominate the entire Q&A, I'm gonna kind of skip some of this. Let's see. Yeah, I agree that the new law that gives the ARC control over, well, no, it's not giving the ARC control over any parcel that can be seen. It's saying that provisions that govern issues that can't be seen are no longer enforceable. So I'm not really sure, George, what that question is. Elizabeth, moving on to someone else. Thank you. For ARB standards and aesthetics is no longer good enough. Correct. Then how can every single issue be reasonably addressed? Again, I suggested the kitchen sink. The alternative is you've got governing documents, your declaration, your covenants. You know, Elizabeth mentions the homeowner wants to put 10-inch LED address numbers on the front of the house. Well, you basically say your house numbers need to be compliant with the association standards, and then the association adopts written standards separate and apart from the declaration. As to each issue you want to address, the declaration needs to say you've got the authority to adopt standards, and then you need to actually adopt them. That's how you address everything. That's how it's been for some time now, actually since 2022. So the fact that this is surprising to so many people, I won't say it's disappointing, but it's a little surprising. Um, Someone asked what EBTR, it's actually DBPR. It's a government entity that I've mentioned a couple times, regulates association operations primarily for condos and co-ops, but some issues for HOAs as well. DBPR, Department of Business and Professional Regulation, is the government entity that we're talking about. Brian asks, if findings not a recommended course of enforcement, what is suggested to ensure conformity with community guidelines with a community that doesn't have common amenities to limit use rights? Well, honestly, you get an injunction or you use self-help, even though I don't like self-help either, but you have a court tell these people you need to do it the right way. Fining people does nothing other than slap them on the wrist and tell them they owe money that the association's never actually going to try and collect. So if your community is very lucky that your members actually pay their fines, good for you. But I see 90% or more of communities that use fining as an enforcement mechanism, finding it ineffective. Because all you're doing is telling someone you owe me money. You're going to look for a money judgment in court. You're going to get that money judgment, and then the owner files for bankruptcy protection and it's wiped out after you've spent 10 grand. It's just a waste of time, in my opinion. So I would suggest that you pursue that through either self-help, meaning if your governing documents allow you to actually go on the lot, you go ahead and take care of the violation and charge the cost to the owner. Now be careful with that too, because you could cause damage. The owner might get violent or verbally abusive. So self-help, that would be my top recommendation. Uh, Elizabeth asks, can two act as a quorum if the committee itself has three members for CEC meetings? I'm guessing that's covenant enforcement. And the answer is yes. Would it make a difference if the two attending CEC members agree? So it would technically make 2 out of 3. The answer is yeah. I mean, if you have a group of 3 that is making decisions and 2 are attending and deciding, then 2 is a quorum and 2 is the deciding factor anyway. So as long as they agree, you're good. Todd asks, how much can an HOA director charge for time to attend this webinar and other trainings? Generally none, unless the members authorize it or it's in your declaration that they can get paid or your bylaws. These are volunteer positions. So all these people that ask to be paid for a volunteer role need to remember that they're volunteering, unless you're actually serving the director and not the members as a director of the HOA.
Hey, Alan, if somebody wants to go to a paid session, like not ours, for example, is it permissible for the association to pay for a board member's education?
Yeah.
You breaking up?
Absolutely. So reimbursement, but being paid to physically sit in inactive board members, you can vote them off as officers, but unfortunately, Michelle, a recall is what would be required until the next election comes up to get that person off the board. Unless you've got an abandonment clause in your bylaws, where, for example, if someone doesn't show up or vote for 3 consecutive meetings, they're treated as having abandoned their post and they're off the board automatically. It's when the board is deciding to remove someone that it becomes problematic. And finally, Carol, if in a developer to homeowner turnover to the capital contributions collected on homeowner closings start immediately being under the control of the homeowner run HOA when that becomes official, not the developer, generally those capital contributions should be paid into the association from inception, but the money gets controlled by the members once you have turnover. So the short answer is yes. And that's it. I want to thank everyone for being here. I know we went over, as I said, we advertised for 2 hours. So anyone that thought this was an hour-long class, I apologize, but I can't give you 2 hours of credit for an hour-long class. So that's just not feasible. And this class cannot be done in an hour. Junior, thank you for your comments. Absolutely. Please, let's share the Empire HOA link. Everyone, please, if I know I mentioned, and I know Denise and Ann are a little more kind than I am sometimes, but listen, I said if you're unhappy with whoever you're working with, please reach out to us. There's a reason we partner with Empire on this ongoing, board education program throughout the year. I think they do a fantastic job. If you're unhappy with your manager or your management, if you're unhappy with your manager, talk to their boss and see if you can get someone else appointed to your community. But if you're unhappy with your management overall and you're not already working with them, I hope there's someone you'll consider because they do a fantastic job. So I want to thank Empire for being here with us today, supporting the education that we all mutually find so valuable and important. Jeff, thanks as always to everyone that attended. Thank you for attending. If you want to reach out to me, my email's been on the screen the whole time I've been speaking, but it's as@kbrlegal.com. I know Jeff's going to provide that once you fill out your surveys, and I'm going to finally shut up. So thank you again.
Alan, you were wonderful. And I don't know if your technology is, can we hear you? You were wonderful. We appreciate you very much. Let me get you back on a spotlight here.
Well, thank you. Alan, that was a wonderful presentation. I very much appreciate it. Yes, I've had some technical issues here as well, but it was very informative. And I've been a board member. I not only work for Empire, but I've been a board member for over 20 years, and it just pays. It's a wonderful opportunity to have these things reinforced.
Well, thank you very much, and we appreciate you having us. We're looking forward to next month. Next month is the 4-hour monster, the condo board. Be glad you're not in a condominium, folks. It's the 4-hour monster.